Hello! Before you proceed to watch this video, I recommend you watch my short video, A Quick Primer, Canadian Legal Precedents and What the R means, to help you understand the premise of a legal precedent if you are at all unclear. The case I'm highlighting today is Faryna versus Chorney is a civil lawsuit case from the Supreme Court of British Columbia, the provincial highest court, but not the national highest court. This case is 64 years old, and it has crept into citations of today's criminal court convictions, including sex offense cases, most recently in the R versus Ururyar case, also known as the Mandy Gray case. Let me emphasize, this is a civil lawsuit case, where the standard of proof is of a balance of probabilities, or also known as a preponderance of evidence, and it is used in criminal prosecutions where we expect the higher bar of proof of beyond a reasonable doubt. The premise of this case was whether or not a man, Chorney, was libelous for reflecting on the chastity of a woman, or her sexual purity, in a personal letter he wrote to another male friend of his. This act of letter writing was regarded as publishing a libelous statement. The woman plaintiff, Faryna, found the letter by accident in a house that they both worked in together as housekeepers, and she interpreted the statement in the letter as directed to her, even though her name was not specifically mentioned. She promptly launched a lawsuit against Chorney for what she interpreted as a libelous publication. Chorney claimed it could not be libelous. The statement in question in the letter was this, quote, "And the one who was cooking for the priests, some say that she went visiting her sister, and others say that she went for confinement. Maybe perhaps you are in it, because it seems you once went with her to the park." End quote. Now for history, the term confinement in those days referred to a woman who was pregnant because she had sex out of wedlock, therefore she would be unchaste. The other problem in this case was the issue of interpretation. The letter was written in Ukrainian, and the three people involved, the third person was a witness who received the letter, were all from a Ukrainian community in Vancouver. So the defendant claimed that his statement could not be knowingly libelous because the reader of the letter didn't know what the Ukrainian translation for confinement was, and he couldn't have known the woman in question was specifically Faryna because her name was not written. The court did not accept this argument and ruled against him. The precedent set in this case was for assessing reliability and credibility. This is the key issue in all she said, he said cases, including the Mustafa Ururyar case and the Gomeshi case, among others that aren't high profile. Can you believe this old-fashioned underlying matter is being used for a standard of credibility and reliability in our criminal courts today? In summary, the meat of the precedent set in the Faryna versus Chorney case is as follows. The credibility of interested witnesses, particularly in cases of conflict of evidence, in other words, statements, cannot be gauged solely by the test of whether the personal demeanor of the particular witness carried conviction of the truth. The test must reasonably subject his story to an examination of its consistency with the probabilities that surround the current existing conditions. In short, the real test of the truth of the story of a witness in such a case must be its harmony with the preponderance of the probabilities which a practical and informed person would readily recognize as reasonable in that place in those conditions. As I said before, this is a standard we would expect in a civil lawsuit, especially a frivolous lawsuit, such as in this case. But why is it being used in our criminal courts when it clearly violates what is supposed to be the high bar standard of proof beyond a reasonable doubt? This shouldn't be the case, and for the life of me, I can't figure out why this is yet to be challenged. Maybe this case doesn't need to be overturned per se, but rather there should be a legislation where, in criminal cases where the only deciding factor hinges on the assessment of reliability and credibility of statements, The standard of probabilities should not be allowed to be introduced into any criminal prosecutions of this type. That alone could potentially put an end to all unfair and cruel she said, he said prosecutions. Well, stay tuned for upcoming videos where I will discuss other criminal case precedents that came along after this one to help make it much easier to reject the statement of the accused.